Good morning, good afternoon, good evening. Our respected speaker for this evening and dear audience, wherever in the world you may be. On behalf of the Department of Law, North Southern University, it is my utmost pleasure and privilege to welcome you to this webinar. Our today's speaker is a prolific researcher, scholar on the topic for this evening, China, Law and Development. I have had the pleasure of reading some of his excellent works published in the last couple of years. The topic is quite, I would say, broad and diverse one. It has quite a few dimensions. I am very eager to see how he presents his thesis, how he concludes, and what his main points are. As I understand it, as Chinese economy is progressing, China is not only progressing economically, it is also working like hegemons have worked. Maybe not in the exact way that hegemons of the past, the Americans or the British have worked, but nonetheless, it has its own ambitions that evokes many responses depending on who the parties are. Obviously, Chinese investments abroad, they are not just propelled by economic considerations. Much of those investments are by state-owned enterprises. They have their distinct non-economic goals as well. And there are also some discerning trends that maybe Chinese BRI and other initiatives, investments are focusing more on soft law than on hard law. And there are, of course, positives from those investments in the host countries, but there are also concerns raised by many groups about the sustainability or the long-term effect of some of those investments. Maybe one case in point could be the 99 years lease of Hambantota in Sri Lanka. So I'm very much eager to see how Professor Erie discusses this and how he views this Chinese approach to investment, Chinese approach to law, and exporting Chinese law to the capital importing countries. With that brief note, it is over to you, Professor Erie.
Thank you so much, Rizwan, for your kind invite to participate in your webinar and to present some research that's a work in progress. I really look forward to the questions and the comments from you and your colleagues and your students as well. This is really a great opportunity for me to learn about sort of these questions from the vantage of colleagues there. So thank you again for this opportunity. I'm going to share my screen. So hopefully people can see this. All right, so without further ado, I'm going to go ahead and kind of launch into this presentation on China law and development. This is part of a 5-year research project funded by the European Research Council in Brussels, and we're really focused on the question of law in China's global development. And this occurs at multiple levels within the both international legal level, but also the level of host states that are receiving Chinese capital through investment aid in other means. So we're operating across a spectrum of legal domains and using in particular the law and social sciences to identify trends, commonalities, and even possible divergences between different host states that are increasingly dependent or reliant upon Chinese capital. I want to begin with this image, which is taken from a page from a Brunswick Group report entitled Understanding Global Opinions of Chinese Businesses, a Growing Divide Between Developed and Emerging Markets. This is a report that came out in 2020, just at kind of the cusp of the COVID-19 pandemic. And I think that the COVID-19 pandemic has probably exacerbated this trend. So what is the trend? You'll notice on the left-hand side that there is the representation of emerging economies, Nigeria, Brazil, Pakistan, Kenya, etc. And according to the respondents of the survey, 80% of the respondents had trust in Chinese companies, and that was growing over the last several of years. And I would say that generally this trend has seemed to, for the most part, increased over the last couple of years. However, on the right-hand side, you see the developed countries, Germany, France, Singapore, etc. And there's only 51% of the respondents who said that they trusted Chinese companies, and that was decreasing actually over the last couple of years. And you can see the associated sort of words in the responses in that survey below the respective emerging and developed columns. So this trend, I think, is really an important one and signals to us that there are emerging discrepancies or divergences in terms of how different types of economies are perceiving the new normal of more Chinese economic actors, primarily private companies, SMEs, but also SOEs as well, the state-owned enterprises, which Rizwan mentioned, that are active in their economies with all of the positive and potential negative consequences of that participation in the local economy. On the Chinese side, one constant is a concern of risk in the countries that they're working in. So it's very hard to get quantifiable data from Chinese companies. It's generally a very difficult process of data gathering. This is actually a survey that was conducted by the China Institute of Corporate Legal Affairs, so a Chinese entity, in Chinese, the 中国公司法务研究院, which is actually set up under the Legal Daily, the journal, the periodical, the newspaper, several years ago. And it really focuses on corporate governance issues that Chinese companies are engaging with. And they've done this survey over the last several years. You see one segment here. This is pre-pandemic information, but nonetheless, I think helpful and indicative of how Chinese companies themselves are perceiving the new norm of going out into countries that may be considered low-income or middle-income countries, according to World Bank indicators. And you'll see that column risks, right? So 39% of the respondents identified unstable political conditions, terrorism, civil war and unrest, military conflicts, et cetera, as a concern. 38% said unstable legal system was a serious concern for those companies that were operating in those systems. And the following year, 2017, 2018, again, incomplete legal systems of host states was a serious concern. So this speaks to legal risk. It speaks to the perception, again, on the Chinese side in terms of conducting business in these economies and working within legal systems that vary sometimes significantly from the Chinese own legal system, right? In the bottom row, you see frequency of disputes. And as a result of some of the challenges of working in these environments, including the legal risks, in that first column, you see 7.9% of respondents were involved in criminal lawsuits, which is fairly significant. 50% were involved in civil lawsuits. So that's a very large number. And then in following years, you see the breakdown as well. For example, 2016-17, 61% involved in civil litigation or disputes. And then again, in the following year, you see that number, a slight decrease, but nonetheless, a high number of lawsuits in terms of Chinese companies being involved, either being sued in these local courts or potentially initiating suits themselves, which is also an interesting trend. So this is just to provide a snapshot of the perception from Chinese companies that are working in these low-income and middle-income countries, and particularly their concern about the legal risks involved in working in those countries. So all of this sets up the kind of questions for this project, which we can break down into three general levels. The first is, how does China protect its overseas investments, right? So what are the mechanisms that are used in order to protect Chinese assets investments and personnel that are working in some of these countries. And in a portion of these countries, there are concerns about expropriation on the economic side. There's also, in other respects, in other countries, there are live civil disputes or even wars. So there's concerns about the safety of Chinese personnel that are working there, either the labor or the managers, right? So how does China protect its overseas investments? What is the toolkit available to the various Chinese actors, either the economic or political, to protect its interests? So that's kind of a descriptive question, if you will. The second question is, oh, I'm losing control of my slides for some reason. One second. The second question is a kind of analytical question, which is, what is the role of law in China's global development? So what role does law play when we're used to thinking about law playing a specific role in terms of economic development? And that is a role that we've learned mainly through the kind of Anglo-American experience promoting law and development in developing economies from the 1960s onward, right? So thinking about transactional security, robust courts, private property rights, administrative law, right? These are all sort of the categories that are familiar to those that have been working in the law and development or post-1990s, the kind of rule of law area for engagement in these countries. But what is the Chinese perspective, right? This is really the critical question. We can juxtapose that and compare that to what we know, but there may also be important differences, and we might want to unearth those and really try to understand what is happening in this space. And then lastly, again, it seems to be my screen is freezing, so bear with me here. What are the effects of China's cross-border ordering? So this is sort of the normative question. What are the benefits that the investment in related activities bring? The benefits may be economic, they may be developmental, they may be by generating connectivity, both internally within the domestic economies, but also cross-border in a very positive way. But what are also some of the concerns? And we'll talk about those in a moment. So that's all very practical or pragmatic, but there's also kind of what I would say an epistemological issue here as well. So as I mentioned, much of what we know about China generally, Chinese law in particular, or Chinese governance, is through the Euro-American perspective. So these are just 4 books that talk about how either historically or in more contemporary periods, much of what we understand about Chinese law in particular is articulated through the engagement of Western actors with the Chinese legal system, going back to the imperial period of Western colonialism, right? And that's informed in many ways how we think about Chinese law today. This is the argument that Timur Raskol has put forward in that second book listed there, Legal Orientalism, right? This idea that China is sort of bereft of law or doesn't have its own notion of law, or that it's the opposite of so-called modern Western law. This is an idea that still, unfortunately, sort of percolates into modern discourse, contemporary discussion about China, think tank analysis, government opinion, and even some academic writing as well. So we want to sort of push beyond the legal Orientalist perspective, and we do that. One way we try to do that, at least, is by foregrounding and highlighting the perspective of those who are from these countries that are receiving Chinese capital. And so we work with a kind of international network of researchers, many who are junior researchers or practitioners, some based in governments or think tanks, but many of them legally trained, some social scientists, who are all working on these questions of Chinese law and development. And so by sort of mooring or anchoring our analysis in this diverse array of perspectives, we hope to decenter the kind of Euro-American perspective, which has been so predominant in how we think about Chinese law and its relationship to economic development and flourishing and well-being. So that's kind of the theoretical, if you will, or sort of the comparative law or epistemological grounding for much of what we're doing. In terms of a kind of brief literature review on this question, the literature is interesting on this specific issue of what is the role of law in China's economic development, which is focused historically, of course, more on the domestic story, right? So in what ways was law playing a positive role in China's own economic growth story? And generally, we can see kind of two different accounts here. The first is the law positive one, right? And this is the idea that the Chinese government in particular has emphasized pragmatism over ideology. This is an idea now that we can take forward in terms of China's growing global footprint in this space, in particular, its economic capacity as it's dealing with more trade and investment issues outside of China. This sort of approach of pragmatic problem solving tends to override ideological commitments to say, for example, socialism, right? Or something like along those lines. And so we can take sort of these nuggets that I'm giving here in terms of the literature review, we can apply them now to the current stage of China's increasingly global economic footprint. But beyond that, as Rizwan mentioned, that we see a propensity for soft law over hard law, and the reasoning or rationale there seems to be that soft law permits more flexibility, more adaptability. It's not, legally enforceable, and that can be beneficial to both parties, or potentially one party that has the asymmetry of power over the counterparty, right? So soft law over hard power. We see also the integration of Chinese norms now increasingly into existing international organizations. This might be through public international law bodies in the UN system, but it might also be in private international law or commercial law bodies as well. And we'll talk about that in a moment. We see for the most part, although there is quite a bit of interest in the Chinese political discourse on the so-called new multilateralism, that for the most part, when you really drill down on the economic relationships and potentially the legal relationships as well that underlie the economic, that it's really the bilateral ties that are important, the bilateral dimension of these emerging relationships. And that's through, for example, bilateral investment treaties that China may have. And China, as you know, has more BITs or bilateral investment treaties than any other country in the world except for Germany, right? So bilateral investment treaties are something that Chinese have taken very seriously. And then dispute resolution. The Chinese are really developing, I would say, creative approaches to resolving disputes that arise in the course of their outbound investment and in their trade concerns. And we'll talk about those in a moment. But on the other side, you have the law negative literature, right? That says that law doesn't really play that much of a role historically in China's economic development, and it's not now in terms of the global dimensions. And they would say it's more about informality. So it's not about law. It is really about the informal relationships that may occur at the ground level, at the industry-wide level, and at the state level as well, potentially. And then related to that, while it's not legal per se, or might not foreground the legal dimension, there are certainly diplomatic aspects to these relationships. And it's really those diplomatic or bureaucratic channels which predominate over legal ones in terms of aligning interests and resolving problems that may arise in the course of some of this work. Related, there's a school of thought in China that would argue that really policy matters much more than law does in China. And they would say that that also similarly applies to these cross-border questions. And then related, that it might be less private contracts and more the governmental presence that is so important in creating order, which facilitates predictability and normalcy in transactions and in commercial relationships. And then related to that, there is this idea of Guanxi, or it's sometimes translated as social connections or social ties, which is predominant in this literature, right, that talks about the informal dimensions of these relationships. And sometimes that is contrasted to legality or law, right? And Guanxi is something that the literature would hold that is not unique to China, but is certainly prevailing in a lot of the commercial relationships. Lastly, the literature would maybe point to a derivative problem from Guanxi informality, et cetera, which is the issue of corruption when you don't have transparent relationships foregrounded and rather have the possibility for relationships that are more sort of backstage, and it might invite certain corrupt practices according to the literature. So there are these two kind of different views, right? And I think what's important to note is there may be truths to both. And in fact, a more syncretic dimension or approach may be more beneficial and more comprehensive, right? But also critically examining each one of these assumptions in terms of how it operates in these outbound relationships is really something that must be done. And so next chart shows some of the differences. This is at sort of the analytical level in terms of what the project is focusing on, the differences between law and development as we understood it historically, again, mainly from the US, to some extent, the UK, France, Germany, and Japan, that have all engaged in sort of the provision of legal development assistance outside of their respective home states, but also in creating order extraterritorially. So again, supporting commercial and potentially political or geostrategic goals outside of one's own jurisdiction through law, okay? And so the law and development literature would point to a number of sort of characteristics that we can then potentially juxtapose to what we see in CLD or China law and development. And the first one with law and development is that, in fact, there was a kind of guiding ideology, at least in the most recent iteration, the 1990s and after, which is neoliberalism, right? So the guiding role of the market, the state was supposed to kind of recede into the background. Again, we get this strong argument for privatization of property rights in particular, and that very much informs sort of World Bank and IMF guidelines vis-a-vis instructions to developing countries. Now, on the other hand, on the Chinese side, as I mentioned, it's not really sort of an ideological drive per se, but really a pragmatic one. And we see this approach to building what I would call transnational law. So less sort of tinkering in the host states and trying to reform the legal systems of host states, which the Anglo-Americans have done historically, but rather building transnational law, mainly through a number of international investment agreements, but also dispute resolution mechanisms that build upon sort of what's come before, that is legal infrastructures that previous capital exporters have established, again, the US, the UK, and others, but also creating new versions of those and creating alternatives as well, so diversifying those, right? Now, in doing so, there's the recourse to not just law, but also extra-legal and non-legal norms. Those are all kind of operative in CLD. Whereas law and development was very interested in sort of, again, as I said, tinkering in the legal reform of the host state, that is the low-income or middle-income country. Oftentimes in the CLD experience, it's more about protecting the interests of Chinese commercial entities, whether the private companies or the SOEs. And so really there's a kind of home state or protective element to what's happening there, less a kind of interventionist one. And then so the next one is on legal intervention, and the kind of metaphor that we use that has become so dominant in the literature on comparative law is legal transplant. So there's this vast literature in comparative law in terms of thinking about how common law, mainly that from the UK, but to some extent from the US, but also Western European civil law has been transplanted through historical processes of colonialism, but also building international legal communities that has then had direct impact on legal development in host states, mainly in the global South, in Latin America, Africa, Southeast Asia, South Asia, and elsewhere. On the Chinese side, for the most part, although there's some interesting possible exceptions, for the most part, we don't see legal transplantation happening. So I think for the analysis, one has to think beyond legal transplant And that's a challenge, again, because the scholarship has really sort of valorized this concept. It's become kind of a keystone concept in many ways. But with China becoming so important in this space, we have to develop new analytical tools with which to assess what's happening. And one of those is, for the most part, if they could, the Chinese commercial actors would do without interacting with these legal systems. And that's one reason why the recourse to transnational law is so appealing. So we can think about, for instance, international commercial arbitration, which obviously was not invented by China, but Chinese commercial arbitration centers have become extraordinarily active in this emerging field of creating more security for Chinese companies that are involved in disputes that involve a foreign law element or a foreign party. Back in law development, we see institution building, so courts, law schools, prosecutor offices, legal aid clinics, et cetera. That was all part of the story, again, really from the 1960s, but mainly from the 1990s onward. And on the Chinese side, we see limited versions of that. In the law and development, one of the key concepts that has become a standard in the literature is this idea of legal missionaries that, for example, professors from Yale Law School would go out to Brazil and they would kind of proselytize the benefits of commercial law from the US experience to teach law students in Brazil about this US commercial law and how they should take this on in terms of their education and ultimately become practitioners in a practice that that is US related, so that they would benefit US companies that were doing business in Brazil, right? So there's this idea of legal missionaries sort of proselytizing US law. In the Chinese case, we see a limited version of this. So this is a kind of, this category is a difference of kind in many ways, that there is not so much this legal missionary attitude, although again, there's maybe some possible exceptions. We can talk about that. In law development, as I mentioned at the outset, there's this sort of legal Orientalist notion that we in the West, we have the best legal institutions, we understand the relationship between law and economic modernization, and that's all been encoded by Max Weber and at the foundation of sociology of law. And that is a very sort of Eurocentric or ethnocentric way of thinking about engaging with legal development outside of one's home jurisdiction. I think that's highly problematic. And so with the China Law Development Project, we're observing these sort of epistemic shifts, as we call them. So how Chinese may not be participating in that same sort of vanguard perspective if it's flipped on its head. So thinking about legal Occidentalism, or thinking that sort of Chinese law is the premier law and that the law, say, of Bangladesh is inferior in some way in this case, but rather having a different attitude. And so the question for us becomes, as researchers, how do we think beyond this legal Orientalist sort of paradigm that has become very, very much sort of molded into the scholarship and the way that some academics think about these issues. So that's sort of the first set of concerns, which are differences in kind. And then there's also differences in degree in terms of the role of the informal. Obviously, there were informal networks in the US and Western European experience with law and development, which, by the way, is not over, it's still happening. But certainly in the Chinese case, we see this enhanced role of informality. It's definitely prominent, and in some ways, trying to keep things out of courts, I think, seems to be a prevailing trend in some of the empirical material that one can point to. And then related to that, network formation, as I mentioned earlier, that networks were not something that the Chinese necessarily engineered or invented. They existed before, but certainly there seems to be this appreciation for and propensity to build networks, transnational networks of judges, of lawyers, of NGOs even that are working on these questions of China-related investment projects. So that's sort of the kind of a march through kind of the analytical frame. And if I can, let's see, move to the next, we can look at, there are certain substantive areas that are a focus in terms of where Chinese actors are particularly interested in making a change or shaping ongoing practices and promoting their own approaches to specific areas of law. So the first, of course, is international economic law because of the volume of trade and investment that China is engaged in. It's the #1 trading country in the world. It's one of the top capital exporters, that is investors globally. And so obviously there's an interest now in shaping international economic law, or if not shaping, then nudging it towards China's own interests. But there's also a set of what could be called frontier, Tianyan, areas of law. And these are areas of law, some are more established than others, but some are certainly emerging. And these are sort of where China may have a first-comer advantage in shaping the norms that exist in that particular legal domain. So data governance would be one, questions of how to control data and control in particular storage or the transfer of data in particular cross-border aspects, development finance. So what are the terms of lending agreements, and what are the principles that are enshrined in these documents? Intellectual property is a very important area where China is pouring a huge amount of resources into, particularly in developing standards that are effectively China leaning, as opposed to based in the EU or the US. Health law, given the realities that we all live in, COVID-19, this is an area where China also is increasingly active in shaping norms at the bilateral level, but to some extent the multilateral as well. International law enforcement, for example, areas of counterterrorism, where this is more a public law question, but this is also an increasing concern of controlling, overseeing Chinese nationals outside of China, questions of capital flight, et cetera. And then oil and gas law, given also the current tragedy in Ukraine, the Russian invasion there. We all are now experiencing increasing gas prices. And so this is most likely the future. And this is an area, of course, where one would want to begin to shape the existing global norms on this issue. And China is no exception in this regard. So these are some of the substantive areas where we see some of the increasing Chinese footprint. In terms of the modalities of how China is doing this, we see three kind of interlinking approaches. The first is networks, building transnational networks of legal and judicial actors that are prominent players in their respective jurisdictions, but also are involved in international legal bodies or regional bodies that may be influential in shaping some of the existing norms. Institutions, potentially building institutions, mainly at the transnational level, secondarily within host states, although that's something we can talk about. And then the practices, what are the commercial and legal practices that revolve around building capacity for Chinese investment and the legal securities that underlie that investment in low-income and middle-income countries. So to kind of break these down, at the network level, there's an interesting discussion that's just emerging in literature in terms of what are these transnational networks that China is promoting. On the one hand, some are very dismissive of them and see them as, you know, fancy trips to Beijing, where people can go from outside China and experience the wonders of Beijing and have Beijing roast duck and, you know, sort of visit the Great Wall, and that's pretty much it. But then there's another side that says, well, actually, there is something very important going on here, that there's this transnational judicial dialogue, to use the expression, that is one that China is putting forward. And it's one that is very much in contradistinction to pre-existing dialogues that were mainly US-centric, and thinking about the sort of the liberal internationalists and their approach to building these kind of networks. I think the truth is probably somewhere in between these two extremes. For the most part, there's a technical aspect to these networks in terms of they can target specific issues in terms of mainly commercial law concerns, but they can also importantly broaden the knowledge of Chinese law by non-Chinese. So China's trade partners in the global South who may not have basis in studying Chinese law, I can kind of expose them to these questions and be beneficial in that regard. And also in the contrary dimension is exposing Chinese lawyers and judges to questions of foreign law. So having that exchange about one's respective legal system and then developing some basis of understanding to deal with questions, for example, in the recognition enforcement of foreign judgments and arbitral awards, which is of increasing concern as more and more disputes are happening both in China and outside of China related to Chinese businesses. Another aspect here is helping with judicial assistance, the service of process in particular, when it involves parties outside of China. That's a very technical or practical concern. More generally, it's problem solving and helping with referrals, connecting people to other people and dealing with issues, and also disseminating information about legal developments in China. So one example that was very prominent pre-pandemic was China's innovations in smart courts. And there was lots of discussion about China potentially providing technology to countries in Southeast Asia, in particular about building out their capacity for smart courts that may be modeled on China's own experience. That really hasn't happened to date, but nonetheless, there is this ongoing interest. And then there's also beyond the technical, the pragmatic, there's a kind of communicative function, which is communicating, ideas of Chinese law and legality, its own legal development story that in the past in China domestically was called pufa, or popularizing the law. So basically spreading knowledge about law. So this is happening now across borders. And then of course, there's a kind of a statist view of this, which is Xi Jinping's thought on rule of law, which is a kind of politicized notion of rule of law that has also been sort of baked into some of these transnational networks. Institutions, there's a lot happening here, both on the international and transnational side, and then also on the domestic law side, but mainly on China's own onshoring of these institutions rather than in host states. But to kind of march through these very quickly, we see China very much working within pre-existing international legal organizations. So of course, the World Trade Organization, which China acceded to in 2001, and China's been very successful in terms of developing domestic capacity to deal with WTO-related disputes, anti-dumping concerns, et cetera. It's been phenomenally successful in many regards in doing so. As I mentioned, China has a vast number of bilateral investment treaties, which is an instrument that certainly predated sort of China's outbound movements, and then also working within various private international law bodies and also other UN actors that are involved in development, whether it's UNCTAD or UNCTAD, and also the Hague Conference, where China has been very active in trying to shape emerging legal norms through those institutions. There's also, Chinese institutions which are alternatives to these existing ones. And these are, for example, very familiar, the Asian Infrastructural Investment Bank, which many people have been reading about over the last several years, the Shanghai Cooperation Organization, which is mainly a kind of an instrument for security. It's a security bloc, but also has economic dimensions. People have been reading about, of course, the China International Commercial Court, and there's also a most recent version, International Commercial Dispute Prevention and Settlement Organization, established in 2019, which uses sort of multiple approaches to dispute resolution, in trade disputes that may arise. So mediation being prominent in that example. So these are all cases that China has taken the lead on. But beyond the sort of transnational, China is also very much interested in domestic innovation and capacity building. So the Supreme People's Court has made phenomenal strides over recent years in terms of building out its capacity to deal with foreign-related disputes. Of course, in the government, the Ministry of Justice, the Ministry of Foreign Affairs are very involved in these conversations. The China Law Society, which is sort of the professional body for lawyers in China, and also very much involved in China's networks with lawyers outside of China, has really taken the lead in organizing a lot of these training sessions and educational opportunities for non-Chinese. And then the All China Lawyers Association also is very much part of that conversation. I would say in international commercial arbitration, we see the most prolific example of Chinese kind of innovation and entrepreneurial spirit, in trying to propose Chinese alternatives to existing ones for resolving cross-border disputes. There are some interesting examples of Chinese co-building institutions in host states. For example, the China-Africa Joint Arbitration Center, which I can talk about in a moment. The third modality that I mentioned, of course, is practices. And so we see this in relationship building, state to state, or G to G as it's called. And this is really the diplomatic and economic aspects, the hard and soft power that are motivating a lot of these relationships in their building, but also at the firm level. So beneath the governments, we see quite a bit of activity. And there, the analysis is focused on the business culture of Chinese enterprises, whether it's the SOEs or the private owned enterprises, their approaches to contracting, the culture of contracting, if you will, managerial relationships with local labor, and the relationship with host state. Those are all really important elements. And then there's kind of a host of other concerns that one could dive into here in terms of practices of Chinese commercial actors, and that is compliance, mainly with local law, the law of host state. In Bangladesh, for example, compliance with PRC law, to the extent that it governs activities outside of the PRC, and then, of course, international law that may have applicability for cross-border transactions. Related attitudes towards law and legality, and also corporate social responsibility, and then the ESG issues that may arise in the course of outbound investment. And then importantly, there are really vital business and human rights concerns in terms of Chinese investment and its impact on local communities in terms of their benefits or their possible detriments in terms of how projects are impacting local actors on the ground. So I wanted to briefly touch on an example here, and this is the example of the China-Africa Joint Arbitration Center, which is a really interesting, somewhat confounding, complicated example of sort of building legal institutions between Chinese and local partners, in this case, African states. So the China-Africa Joint Arbitration Center, very briefly, was the result of efforts really principally led by the China Law Society circa 2015, working through FOCAC, the Forum on Cooperation between Africa and China, mainly on economic issues. And so the idea here was to develop an institution that would support China-Africa related trade and investment and help in resolving disputes that arise in the course of that cross-border business. And so this was an institution that was initially spearheaded by a number of arbitration commissions on the Chinese side that then developed partnerships with organizations on the African side. So it was on the Chinese side, you had the Shanghai International Arbitration Center, the Beijing International Arbitration Center, and the one in Shenzhen, the Shenzhen Court of International Arbitration, working with partners in South Africa, Nairobi, in Kenya, that is, and then the OHADA system, which is the Francophone. There's 17 French-speaking African states. So effectively, the idea with KJAC is that there is a kind of arbitration center in each one of these regions or municipalities, as the case may be, and that they deal with disputes that are related to China-Africa business, and that parties can select for specific venues for their disputes, and that they would resolve these concerns. And there's a kind of fascinating institutional history here in that initially the rules as those of you who are familiar with arbitration know, that there are institutional rules for arbitration centers, right? And so initially the blueprint for the KJAC rules came from SKIA, the Shenzhen Court of International Arbitration. So that's a really fascinating example of a potential sort of, you would think about it maybe as a transplant, but I think the story is more complicated, because ultimately it was discovered that the Chinese arbitration regime was inconsistent with the arbitration regime in South Africa, which is an UNCITRAL state. So they abide by the UNCITRAL model law on international commercial arbitration. China does not. That's a different story. But there was a disharmony between the two. And as a result of that, they had to create a new set of rules. And this is an excerpt, Article 3 of the 2020 Uniform Rules that I've excerpted here, that basically creates a tiered system, a two-tier system where you have uniform rules, but then you also have local rules. And parties can opt into the local rules when there's a disagreement between the existing Chinese regime and the African regime. So that was a kind of measure to deal with the problems that arose in the course of building this institution. So ultimately, the Chinese footprint in terms of its legal transplant, if we use that term, did not really have that much traction in this case, that it was basically phased out because of the disharmony between these different systems. Okay, so I know that my time is almost up. I'm coming to the last couple of slides. So one of the things to think about here is whether or not this Chinese approach is viable. And one way to think about it is that it has had a measure of success. And we can measure that by the degree to which other powers are now mimicking China. So for example, the US has the Build Back Better World project. The EU has the Global Gateway project, and India has its ideas sort of scheme. And these are all basically seen as rivals to the Belt and Road Initiative. So it's fascinating that despite the criticism, and there's ongoing criticism both from Western states and from local host states, that there is this kind of mimicry happening. And what we can see here is really China is setting the agenda for international development. It's one that's primarily infrastructural in nature, and it's one that the previous capital exporters and powers that were involved in this area of international development are sort of taking on board. So I wanted to end with sort of set of questions for colleagues there sitting at North-South University, and that is, what does this mean for Bangladesh? And clearly, China is a major economic partner. After Xi Jinping's visit to Dhaka in 2016, there were some 27 agreements that were signed by Xi and the Prime Minister Sheikh Hasina. And the relationship between China and Bangladesh was elevated to, quote, strategic partnership of cooperation, right? Bangladesh is one of the largest recipients of Chinese loans in the world. China is a major investor in Bangladesh, particularly in infrastructure and in energy projects, electricity and nuclear. And there is a serious trade imbalance in terms of much more imports from China going into Bangladesh rather than Bangladeshi exports going into China. So these seem to highlight a number of concerns in Bangladesh. And so the questions that I have are, given China's sizable economic footprint in Bangladesh, what are the debates about China's presence there in the country? Related, who are the important stakeholders and what are their views? So obviously Bangladesh is a very complicated society. There's governmental views, industries have their own perspective, civil society, NGOs, academia, and others all have various views. What are they? And thirdly, what is the normative framework for this economic relationship between the two countries? Is it the bilateral investment treaties and the free trade agreements, but also do we see legal cooperation, judicial networks that are forming? And lastly, how can we here in the China Law Development Project based at University of Oxford help build knowledge with Bangladeshi partners on this important topic? So I'll end there and very much look forward to your questions and comments. Thank you.
Thank you, Matthew, for your excellent presentation. I do not know if I can speak for North-South University or for that matter for the Department of Law, but my 2 cents would be that our government is sort of trying to trade a balance between the influence from India, or another big neighbor, China, and of course there is also the Western pressure on certain matters. You might be aware of the debate about the deep sea port in our country, and there are other issues of investment. Now, with regard to the MOUs or the 27 agreements that you have referred to, I don't think there is enough public engagement or enough public discussion on that. And so far, it seems to me, at least, I would speak for myself, not for our department or the university. I think it has mostly been driven by diplomats to diplomats, government to governments. I do not see enough engagement from the business or from us, the academia. With regard to engagement with you, maybe I would say the kind of dialogue that we are doing this evening, maybe this could go on. And obviously, if an opportunity arrives, if there is something in which we can contribute to your CLD project, I can speak for myself, and I hope on behalf of my colleagues at the Department of Law, that we would be surely delighted to be a small part of your project if we can contribute in any way. Now, the questions that we have received, the first question that I'd like to put to you is on the legal transplant that, unlike the US or some other dominant powers of the past, as you have alluded to in your presentation and also in your paper, that China seemed to be reluctant to engage in that legal transplanting. Now, what could be the rationale behind that choice? Any thought on that, Matthew?
Thank you, Rizwan, and thank you also for your kind of opening comments in terms of your reflections about where Bangladesh is, its geostrategic position. I see this in a number of smaller countries, if I may, in terms of trying to hedge between different major partners and neighbors, right? So in your case, China, India, then of course the Western powers as well. And so there is a literature on this question of the hedging capacity of small states, and also through international law. There is an increasing nascent literature, I would say, on this question in terms of how smaller states can work through international law to protect its interests vis-a-vis potential rival powers, that is economic hegemons or major economies rather. And so I think Bangladesh's experience is really important. I think it should be, it should be examined, it should be reflected upon. And I do hope that, we can be part of we can build a conversation here. And I very much look forward to speaking with you more about this. So that's just at the outset. And then on the question of legal transplant. So I think, yeah, it's a really interesting question. And I think you have to look at both the supply side and the demand side. On the supply side, I think the questions are the following. Is China confident in its law? Is China confident enough in its law to export it to other countries? You have to remember that the Chinese legal system really was modernized effectively from the early 1980s. So that's, when the Gaiga Kaifan, the opening reform really happened. And so the legal system in China, even though there's this incredible, vast history of law in China, that the modern law is relatively recent. Now, having said that, it has had exponential growth. And in fact, I would put forward that the Chinese legal system has grown at a volume and at a pace that outrivals any other country in the world. There's really been a premium put on legal development in China. And it's in particular areas. IP law, I think in particular, has been an area where the Chinese have focused on investment law as well. The recent foreign investment law is a major milestone. So there's a lot to be said there. However, I would say that in terms of that confidence or the overconfidence, and some would say it's a hubris that one would need to export their law to transplant it to other states. That's, I would say, the Anglo-American experience. The Europeans are very different on this. They talk about the Brussels effect and how other states and commercial actors are drawn to EU law. It's a very different sort of mental state, if you will, or way to frame it. It's much softer. I think the Japanese and the Chinese view is even softer yet. And we haven't yet seen the kind of interest in exporting law, although that may be happening in cybersecurity law. But there, I think it's much more about, and this gets to the other prong, so not just the supply side, but the demand side, where host states are interested in what China is doing in specific areas. So cyber law, cybersecurity, notions of data sovereignty, intellectual property, the relationship between data and technology more generally. I think those are the areas where China is really trying to, establish itself in terms of a first-comer advantage, and where other states are looking to China maybe to learn some lessons. So I think that's I would focus a lot of the analysis on the demand side, and there, countries like Bangladesh have a menu of options. You can look at what's happening in the UK, in the US, potentially in Western European states, but you could also look at India, you could look at China. So you could look at all of those in terms of where you want to borrow ideas from, legal concepts, principles, statutes, even to integrate into the legal system. And so there's optionality. So China may be one possibility amongst many. So I think we really have to, again, think from the host state perspective. So I probably spoke too long, but that's my answer to that question.
Thank you, Matthew, for that answer. And one additional point, I think you raised 4 questions. So one of the questions that I forgot to answer was on the basis of a legal relationship, that do we have FTAs or BEATs or other treaties with China. As far as I am concerned, we are one of the countries with very few FTAs, apart from the South Asian Free Trade Agreements and then BIMSTEC and some with the Islamic states under D8, which is not really very much functional. Apart from these, we, as far as I know, there is no formal FTA with China. But we, I think, have a functional investment treaty, a BEAT, signed somewhere in the 90s. I cannot recall the exact year, but I think we have a bilateral investment treaty with China. That's about formal legal answers. Now, the next question that I would like to put to you is on the Chinese approach, or any discernible difference in Chinese approach when it comes to investment in the developed world and the developing world, because China is not just investing in the developing countries. So much of the Chinese investment is also in the Western world, I guess. So do you notice any different approach or any trend there?
Yeah, so certainly that there's no question. In fact, there's a huge volume of Chinese investment that's flowing into developed economies, the Western democratic states. The U.S. has, pre the Trump administration, was a major recipient of Chinese FDI. What are the differences? Well, so that's interesting you asked that question. My friend and colleague Chi Li at University of California, Irvine, has written a book on this question of Chinese investment into the U.S. He's writing a second book right now on this question. We talk about this all the time. And I think what he sees and others see in terms of Chinese investment in the U.S. and other Western developed states is that there seems to be a bit more of when in Rome, do as the Romans do, although that adage could actually apply also to developing countries as well. So one has to be careful about making sort of grand statements. But in terms of compliance, in terms of hiring local lawyers, in terms of thinking about working with local institutions and the courts in particular, there seems to be more amenability by Chinese parties to kind of fully integrate and interact with the legal systems in the US, the UK, et cetera. It's kind of unavoidable versus other countries that, may be climbing out of a economic recession or, a civil war or some kind of large scale political unrest. The legal system and the judicial system in particular may be at a sort of nascent stage of redevelopment. And there, I think there's a concern about interacting with and engaging with that legal system. And so I think that is a main difference that we can see. And that then gets the argument that the Chinese may be spearheading or kind of initiating this building of transnational law, which I think certainly applies to many of the developing countries. It may also apply to the developed countries, but potentially less so. So maybe there's a difference of degree there rather than kind.
Thank you very much, Matthew. The next question that we have is on the foreign corrupt practices law as it is applied in the Chinese legal system. We know that there is something in the US called the Foreign Corrupt Practices Act 1974. So do you see any parallel law in China? I think you briefly mentioned this in your presentation. So what is the trend there? Do you see any practical application, or is this playing a role in the practice in China? Is it a relevant factor for the Chinese investors investing abroad?
Yeah, great question. So the short answer is not really. So China does in fact have, don't quote me on this, but I think it's Article 164 of the criminal procedure law, where it has a provision that specifies that Chinese nationals who bribe officials overseas, that the prosecutor can obtain jurisdiction over those nationals. And the idea is that basically to curb bribery towards foreign officials, right? Which is very much the idea of the Foreign Corrupt Practices Act, which you cited. And interestingly enough, if you look at the legislative history of that provision in the Chinese criminal law, in fact, it was the US government that really sort of pushed China to adopt that provision into its rule. And so that's an interesting example of, again, the US sort of promoting its values, its legal transplants, if you will, to other states with the idea that it creates so-called best practice. But to date, I've looked, I mean, not too recently, but a couple of years ago, I looked and there were very few cases on that law. So the judges in China are not, and the prosecutors are not bringing cases that cite that particular provision. And the question here is why not? And I think one possible response is that, well, in many respects, there's different answers to the question. One is that China doesn't have the capacity to regulate behavior of Chinese nationals and Chinese companies overseas. And so it's just a capacity issue. Other people say, well, that doesn't really seem to make sense because China has quite a bit of legal enforcement capacity now, particularly in the Pacific Islands. It's developing networks all around the world to go after Chinese nationals, corrupt officials, et cetera. So the other argument is that, well, the Chinese government isn't incentivized to prosecute Chinese companies because their projects may be more, and their activities may be more in line with the Chinese government. And so there's not really an incentive there to go after them. And you have to remember the legislative history of the FCPA and the US experience was that it was the divergence between US companies and what they were doing overseas and the US government, that the US multinational companies were getting involved in local politics in a way that worked against the interests of the US government. And so the US government wanted to reel in the US multinational corporations to stop their behavior, to make sure that there was more alignment. And I think that alignment sort of already occurs in the Chinese case, but I could be wrong.
Thank you so much. We are already out of time, but I would take this opportunity to ask one last question. This is on the role of Chinese institutions in the shaping of global legal order. Do you see them playing any active role or any consistent pattern, any design there? Thank you, Beth.
So yeah, I think Chinese legal actors are increasingly relevant at multiple levels, like I mentioned. I mean, the Chinese are very active in the WTO, in the UN system, UNCTAD, in the Hague Conference. They're sending representatives, but also beyond the multilateral and the established institutions, the Chinese domestic institutions are very focused on these issues. One of the current sort of things that Chinese legal academics are talking about is the so-called 世外法治, or foreign-related rule of law. And the idea here is that China can help integrate its legal system into the international legal system, and that would have effects both on the onshoring of legal issues and legal disputes, but also potentially informing legal institutions outside of China and shaping them more in the image of Chinese legal institutions. So the Supreme People's Court is involved with this. As I mentioned, the Ministry of Justice, the lawyers, the arbitrators, and academics are all heavily involved. And so I think the question will be, you know, not just for Bangladesh, but for other countries all over the world, the US included, what does this look like 20, 30 years from now? If in fact, you know, there is greater influence and a greater footprint of the Chinese and global legal norms, where is the world at that point in time? Is it better off or not? So that's the kind of question I leave people with.
Thank you, Bathu, for a parting thought. I think that's very apt. Thank you for your presentation and thank you for your answers to the questions. Dear audience, thank you for your time. I wish you have a good day. Bye.